Those in favor of the motion say aye. Against say nay. That's have it. Clerks invited to read the long title of the bill.
Amend the Electoral Act number 13, 2022 and for related matters. Third reading.
Bill read the third time and pass.
Well, I think naturally laws sometimes are made as like, they're like living things. And when you have living things, you need to take care of them. Where you have need to do what you can call cosmetics, you work on it cosmetically. Where you need to do some legislative amendments to update them with the global best practices, then definitely you will expect such things to happen in the parliament. So what we did today was not any different or far from our normal practice. That we have found a cause, not just a cause, very compelling cause, that we needed to amend to be able to address some lacunas, issues that if left as they were, then definitely we will have a problem in our electoral process. Fundamentally, it was to do with the issue of statutory delegates. The provisions or the use of statutory delegates, and when we say statutory delegates, we mean delegates arising from elected political office holders, right from Mr. President, the Vice President, the Senate President, the Speaker, and the body of those elected people within the realm of our democratic process, from head to toe, cutting straight from the federal here down to the sub-nationals. And there was this omission that in the context and the content of the law, the electoral legal framework as it were, we have unfortunately, and I think we are human, omitted that aspect. And it has been embodied virtually in all the statutes documents of the political parties. There are provisions in virtually all our political parties for the use of statutory delegates, elected office holders, to participate in the selection process of candidates, which in other words is called party primaries. So at that point, when we were briefed by our legal department, we also had to interface with the office of the attorney.
180 to 150 and this confusion. Yes. It's members' assumption. That the second one that talks about 180
is already provided by this arm of government. I want to say without any fear of contradiction that no one arm of government can, under whatever circumstances, take away our constitutional powers. We have the right, the constitutional right bestowed in us by the Constitution, the supreme document of the land, to make laws. And when we make laws, using the instrumentality of law around us to do the laws, such laws must be respected under whatever circumstances. And for any arm of government, whether court or whatever, to now begin to use the instrumentality of judiciary or instrumentality of interpretation of laws to begin to distract this institution from doing our job, that cannot be accepted. I don't have problem with any court passing any judgment, but any court that passes a judgment against us discharging our constitutional duty, I say they are on their own. Thank God, this court that has passed this judgment is not the highest court of the land. We will exhaust all apparatus, we will exhaust all avenues, judicial avenues, to make sure that the right thing is done. I don't think what we have done, as far as the laws are concerned, there was anything injurious to our system. What we were trying to cure in our Constitution and in the Electoral Act was not for anything, it was for us to improve on the conduct of our election process.